This case study is about the probation period contract issue between a Chinese indigenous company and an employee. Therefore, the Chinese labor law will be applied to this case study. A is a Chinese indigenous company. Its HR decided to hire B person to work for their company. However, the HR contracted with the B person verbally. They agreed for the probation period as 3 months. The salary during the probation period is 1,800 RMB. If the company thinks that B person is not the ideal one for the job during this 3 months probation period, then the company has the right to cancel the employment with the person B without paying any compensation. If the person B completes 3 months probation period successfully, then the company will offer the person with an 1-year employment contract. Simultaneously, the salary will be increased by 2,500 RMB. There are 3 main issues in this case study. The salary of the probation period cannot meet the minimum requirement of the labor law in China. Verbal contracts are not legal for hiring people, not only in a way of formal contract but also for the probation period. The third one is that the 1-year formal contract requires no longer than 2 months probation period based on the labor law in China. Based on the labor contract law of the People's Republic of China, Article 19, it stipulates that if an employment contract has a term of not less than 3 months but less than 1 year, the probation period may not exceed 1 month. If an employment contract has a term of more than 1 year and less than 3 years, the probation period may not exceed 2 months. And if an employment contract has a term of not less than 3 years or is open-ended, the probation period may not exceed 6 months. This law protects workers' rights in the case that some companies set too long probation period. In this case, the probation period is 3 months, which is not legal because the company only will sign a 1-year formal contract with person B. The Chinese labor law stipulates no more than 2 months probation period if the formal contract no more than 1 year. This law guarantees the basic economic needs of the employee of the probation period. In this case, the company only offers 1,800 RMB to person B. Actually, according to this law, the salary 1,800 RMB is not legal. The lowest legal wage of person B should be 2,000 RMB. According to the labor contract law of the People's Republic of China, Article 20, it stipulates that the wages of an employee on probation may not be less than the lowest wage level for the same job with the employer or less than 80% of the wage agreed upon in the employment contract, and may not be less than the minimum wage rate in the place where the employer is located. Based on labor contract law of the People's Republic of China, Article 10, to establish an employment relationship, a written employment contract shall be concluded. In the event that no written employment contract was concluded at the time of establishment of an employment relationship, a written employment contract shall be concluded within 1 month after the date on which the employer starts using the employee. Where an employer and an employee conclude an employment contract before the employer starts using the employee, the employment relationship shall be established on the date on which the employer starts using the employee. This law stipulates employment contract should be in a written form rather than in a verbal way. In this case, HR contracted with the worker verbally, which is actually illegal. In this scenario, HR needs to show a formal and written contract with the worker. Therefore, based on this case study, we made 3 conclusions to summarize this case study. The first one is that the establishment of the labor contract law is an important measure to respect and protect workers' benefits and interests. The second one is that the labor law in China requires a formal written contract rather than verbal promise. The third one is that the minimum probation period salary is to ensure the basic economic needs of the workers.